So that's my concern.
Yeah, you are. Yeah, the judge can, yeah, but you just requested you live with your mom, but she said, she may have a place in This judge, I did a separate one for all of them, but the Senate, the plea, the offer was all the same.
Trahan, in cause number 25, DCCR 1094, you're charged with the state jail felony offense of unauthorized use of a vehicle. The indictment alleges that you were previously convicted of accident involving injury or death, a special felony on October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, a second-degree felony on that same day. What that means in that case is that if you're found guilty and those prior convictions are true, the punishment would be enhanced to that of a second-degree felony.
This is where the case gets serious. When the judge explains enhancement, it means his prior convictions are increasing the punishment range. What might have been a lower level sentence is now elevated to a second-degree felony carrying 2 to 20 years in prison. In a courtroom, those sound like just numbers. But in real life, that's decades. So now the real question becomes, do you take the dealer risk going to trial?
So it would be a minimum of 2 years up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1317, you're charged with possession of a controlled substance, a state jail felony from December 28th of 2024. It alleges those same prior offenses. And so in this case also, if you were found guilty and if the those prior convictions were true, then you would be enhanced to second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then finally, oh, wait, hold on. In cause number 25, DCCR 1536, you're charged with a third-degree felony offense of, evading arrest or detention with the use of a vehicle from August 20th of 2025. The indictment alleges those same prior offenses, which in this case means that you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
In all of these cases, I have here on the tablet the plea bargain rejections that you've signed with Mr. Parker. This shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 10-year terms in all of those cases. And so that would mean in that last case, the evading going on count one only for the 10-year term to run concurrent, all three of them. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes.
And Mr. Coleman, is there any reason to anticipate that there's any other evidence that you haven't received that would change that offer?
Not at all, Your Honor. In fact, the state will be filing a motion to accumulate the sentences in all three of these cases.
So I do want to make sure you also understand because these are different offense dates, there is the potential, if you're found guilty in all three of the cases, that any sentence that you received from a jury could be stacked on top of each other. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this plea agreement. You understand?
Yes, ma'am.
All right, then I will get your cases set on the trial docket. Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation a little quicker. Is that okay with you? All right, Mr.
Your Honor, as I've told the court, he has Brian Matuska as a parole lawyer, and he would be fine with Mr. Matuska, but it's obviously up to the court.
I'll take a look at it. Typically, it's just a rotation. If Mr. Matuska is already handling something for you, we'll contact him, and if that works out, we'll appoint him. If not, then it'll just be somebody off the rotation.
Yes, ma'am.
Okay, you can go back with the bailiff. Good morning. Are you Allison Strom?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the indictment?
No, Your Honor.
Ms. Strom, in cause number 25, DCCR 1370, you're charged with a second-degree felony offense of assault on a peace officer And that's from August 23rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 3-year deferred probation. You would be on the specialized caseload for any issues that you have going on, and then required to follow all of the other rules and conditions of probation. Is that your understanding?
With community service, correct?
Community service, reporting, drug testing, anything through MHMR, mental health treatment, anything like that, you will be required to do as part of your probation. Do you understand?
Yes,
Okay. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State.
And now the stakes rise even higher. The state plans to stack the sentences, meaning they could run one after another instead of all at the same time. That's how time quietly multiplies. A 10-year concurrent offer might sound heavy, but if convicted at trial and the sentences are stacked, the total time could be far worse. This isn't just a legal decision, it's a gamble with years of freedom on the line.
Tenders number 1.
No objection.
It's admitted. I have to ask everyone that about the citizenship.
I'm American.
Everybody.
I had no doubt you were, but I have to ask everybody, okay? States number 1's admitted. Is there any evidence that Ms. Strom is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing.
She's requesting a personal bond just because she doesn't have the means to bond down.
Judges, if I may.
And she and I'm sorry, I think she wanted to go to live in Houston
Yes, sir.
with her mom in Houston.
And that would obviously be a better place for her than maybe here in Beaumont. I don't know if the court is familiar with the probable cause. I have it here. So as not to really embarrass her in open court, there were some issues. The officers were trying to effect an emergency detention arrest for her own safety because there was some mental episode of sorts going on. And so my concern is that she would immediately go to MHMR or immediately go to her mom's house and remain there effectively under house arrest until some sort of evaluation and help for her can be put in
Right.
place so that she doesn't harm herself.
I guess my concern is during that period that she's not on probation, I'm not sure what access she has to Spindletop without it being court ordered.
Where does she be living?
Well, she's wanting to go live in Houston with her mom, and so I would want services obviously there, so that wouldn't be Spindletop, it would be Harris County, I can't remember.
They do have one.
I just don't know, it would be a condition of probation, but not a condition of bond. I don't think I can, so that's my concern.
Yeah, you are. Yeah, the judge can, yeah, but you just requested you live with your mom, but she said, she may have a place in Belmont she could live on.
Well, here's what I'm worried about is if I let you out on bond before we order probation and we have the conditions in place so that you can receive the treatment that you need, I need you receiving some treatment between now and then. Go ahead, yeah, tell me.
I have a prescription I have the full prescription currently. Some of it's in and security, and then some of it's at my mom's.
Okay,
That was part of the issue. She wasn't taking her medication when this happened.
So
okay.
that would,
So you understand, obviously, at this point, that you have to take the medication.
Yes, ma'am.
No matter how it makes you feel, good or bad, you have to take it.
No, I've been taking it every day while here and consecutively for the 2 months.
Good.
I've noticed a difference.
You feel better?
I feel I have a little bit more hope.
Good. So, all right, so here's what I'm going to do. I'm going to reduce your bond to $1,000. I'm going to make it a personal bond, which means you don't have to pay money. I'm going to order, so you're just going to be released today.
This one.
But I'm going to order, I want you to go live with your mom. If that's the best place for you, you have medication there, she understands what's going on. So you're ordered as a condition of that bond to continue taking your medicine. You're ordered to go live with mom.
Okay.
You need to make sure you know how to get in touch with Mr. Parker. If something happens and it doesn't work out with mom and there's somewhere else that you need to go, you need to let him know so that I can give you permission to go there.
Yes, ma'am.
Okay? Also, you're going to have to go.
Here the tone shifts completely. Instead of prison time, we're hearing about probation treatment and conditions for release. The judge is focusing on rehabilitation, especially with mental health concerns involved. Personal bond gives freedom but with responsibility. This shows the system can balance accountability with support. The opportunity is there, but it has to be taken seriously.
Go to the probation department here as soon as you're released so they can start that pre-sentence report.
Do I
Okay?
go today?
Today, it depends on what time that you get out. So if you get out before 5 o'clock today, then it's better to go straight there today. If not, you'll go first thing tomorrow morning. Today, you're going to get some paperwork before you leave court today that has the address, where you're supposed to go, and everything. So don't leave and go to Houston before you take care of that appointment.
I have somewhere I can stay for the day.
Okay, perfect. All right, any other questions? We're good? Okay, we'll see you back at sentencing.
Yes, ma'am.
There's 3 cases.
Are you Quincy Batley? And will your client waive the formal reading of the indictment?
He would.
Mr. Batley, in cause number 24 DCCR 1295, you're charged with the third-degree felony offense of unlawful possession of a firearm by felon from June 28th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Mallet is not Mr. Batley is not competent?
No, no.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
And just like that, 5 years. The plea agreement is accepted and the right to appeal is waived. That's the trade-off: certainty over risk. 3 defendants, 3 very different outcomes. Every decision in this courtroom carries weight. So if you were sitting there facing that choice, would you gamble at trial or lock in the deal?